Okay, so Fred joins us again. He's of counsel with HBL. He's working with clients all over the country for us with their employment law needs. 30 years of experience, first chair trial experience, a super lawyer. Fred's reputation precedes him. And so with that, I will hand it over to Fred.
Thanks, David, and thank you everyone for joining us today. As David indicated, this presentation is going to be pretty full. Dealing with investigations, there's a lot of different components to it, and I'm going to try to move through the material quickly, but not rush it. The question box is available to the extent that I don't address something that you'd like to see covered. And after the presentation, if you have a question, you can send it and I'll address it as I'm able to. I'm going to remove my video cam and just dive right into the presentation. So my experience is in helping businesses manage personnel related issues that have some kind of legal dimension. In addition to providing day-to-day counseling, I have represented companies in jury trials as lead counsel. And that experience gives me, I think, a unique prism to provide advisement about how investigations should be conducted and how they may play out if you find yourself in some kind of adversarial proceeding. There are a lot of different reasons why you want to conduct an investigation, but probably the most important reason is to enable you to assemble the information that will allow you to make the best decisions that you can make. In addition to providing you with the ability to make the best decisions, doing an investigation can allow you to sometimes create a strategy to manage those issues that might come out of the results of the investigation. Lucy, if you could go back one slide, I seem to have skipped ahead. Thank you. One of the benefits, among the benefits of conducting an investigation is that it puts you in a better position when you're dealing with a third-party agency. Here in the U.S., the U.S. Equal Employment Opportunity Commission is most often the administrative agency that will be performing some kind of analysis of your workplace practices. If an employee brings a charge of discrimination with the Equal Employment Opportunity Commission, that agency will do some level of investigation to determine whether or not they believe the law has been violated. Now, as with many federal agencies here in the U.S., the EEOC has limited resources, so there's only so much that they can do by way of conducting an investigation. But if you do an investigation and are able to lay out the specifics of the complaint that's been filed and how the complaint has merit or the extent to which it has merit, being able to provide some kind of assistance to whatever investigator wants to look at your practices helps them create some goodwill and can help shape how they assess whatever information they gather. When you do the investigation, although you want to put your company in the best position possible, it needs to be an objective investigation. There have been a lot of news stories over the last year or two about investigations done in the political context and in other contexts. And one of the criticisms of those investigations is that they're not objective, that the person performing the investigation has some kind of tie to the entity that's requesting the investigation. So to the fullest extent possible, the investigation needs to be accurate and objective. In addition, you don't want to leave any stone uncovered. The best thing you can do is to get at the good, the bad, and the ugly, rather than do the investigation and then down the line find out that there are some additional witnesses or some additional elements to the investigation that you now have to circle back and try to run down. The downside to doing an investigation is that you may provide a roadmap for someone to file a lawsuit against you or for an agency to initiate some kind of compliance related proceeding. Be that as it may, the benefits of conducting the investigation, in my view, outweigh providing a potential roadmap for some kind of adversarial proceeding. And even if it does give that agency or the plaintiff some sense of how you have handled the complaint or the matter and how you believe you did it appropriately, as long as you've done everything that you can do in terms of vetting the complaint, taking remedial measures, the fact that the other side may know about it should not impact your ability to successfully deal with the situation. One of the things that shapes how the investigation is going to be done is whether it's done pursuant to some kind of regulatory or statutory requirement or company policy, or if it's done in response to an employee complaint or an external complaint by some third party who does business with the company. And I'll speak to how those two different types of investigations look a little bit different. When you have a concern or a complaint that needs to be investigated, you should first think about who is the best entity or who is the best person within your organization to conduct investigation. If it relates to a human resources issue, that is harassment or discrimination or some kind of difference in personality that's leading to disruption within the workplace, then human resources is generally the best department to conduct that investigation. If the matter involves some kind of billing or an element of fraud or some kind of regulatory matter, then a compliance specialist, if you have a compliance department within your organization, would generally be the best person to lead that investigation. If the matter concerns assets being misappropriated or some kind of financial irregularity, then your internal audit team or someone from your legal department is probably the best entity or the best person to move that investigation forward. Now, there are occasions when, given the nature of the complaint, it makes sense to outsource the investigation to an independent investigator. I've done a number of investigations, particularly over the last 2 years, where I have no connection to the company, but they need someone who has no such connection to come in and provide an independent investigation. The benefits of that are I don't answer to anyone within the company except the person who engaged me. I don't have to worry about making someone upset and that having an impact on how my performance is going to be evaluated at the end of that year, or someone having the ability to determine whether I'm going to be considered for a promotion or so forth. So even though these guidelines about who should best conduct investigation when it's going to be done internally, I'd encourage you to keep them top of mind. Also consider when it may be useful to bring in a third party to conduct that investigation. One of the first things I do, and what I'd encourage you to do when you do an investigation, is define the scope of the investigation. Identify who it is who's alleged to have engaged in the misconduct or committed the act which generated the complaint. The next thing that I do, and I'd recommend you do, is identify the specific policy or law that was allegedly violated. If it's a harassment complaint, is it sexual harassment? Is it racial harassment? Does it involve a violation of the company's conduct policies? If so, which specific policy? To the extent that you can, identify the specific policy within the company that's involved, and that will help shape how you look into whether or not the complaint has validity and what remedial measures you might need to implement. Even though a complaint might grow out of a violation of one specific policy, there may be other policies that are implicated. For example, if it's a harassment situation, that may fall under your anti-discrimination or anti-harassment policy, but it also may fall under your workplace conduct policy. So although you should endeavor to tie it to a specific policy, keep in mind that there may be other elements of your workplace practices framework that might be implicated. When defining the scope of the investigation, determine whether it's being done to comply with a company policy or to obtain legal advice. Here in the US, if it's to comply with the company policy or to obtain legal advice, that impacts the extent to which attorney-client privilege might apply. And that, in fact, that in turn impacts how the investigation will be conducted. That is, who's going to do the investigation, what questions are going to be asked, what disclosures have to be made if an in-house counsel is doing the investigation, how the investigation results are going to be memorialized, and the extent to which the results of the investigation are going to be communicated with a third party. When conducting an investigation, I'd encourage you to start the inquiry as broad as possible and to narrow it as the investigation moves forward. Using the example of a harassment context, if someone comes to me, one of my clients comes to me with an allegation of, say, racial harassment that they want investigated, I'll start with any asking about any racially inappropriate conduct. If there's a specific incident that's involved, I'll go beyond that to ask, in addition to this incident, have there been other incidents that you believe violate the company's policies? And then as I move forward, I will narrow the investigation to focus on the specific allegation that's brought forth. And the reason I do this is because sometimes the complaining party won't necessarily remember everything unless you give them that prompt and give them the ability to articulate other concerns. Many years ago, I did an investigation of workplace sexual harassment, and I interviewed the complainant, the woman who alleged that she had been harassed by her boss. And the interview, this was the longest interview I've ever done. It took about 11 hours. And at the very end of the interview, I asked her if there was anything else that she wanted to bring forth. And she said, oh, yes, he also sexually assaulted me. So although I started broadly and narrowed it down, giving the person that platform to bring up forth other concerns allowed that very serious allegation to be enfolded into the investigation. One of the first things you also want to do is identify the potential witnesses who might provide helpful information. Many of those witnesses are going to be folks who work inside the four walls of your organization, but sometimes they're going to be individuals who don't work for the organization and over whom you may not be able to exercise the same level of control. To the extent that you have to ask questions about or ask questions of vendors or suppliers, then you should develop a strategy about how you're going to do that. And developing such a strategy is important because if it's an external person, you don't have the same ability to limit them discussing the investigation with other people or limiting their ability to share the information and what you've asked them with whoever they deem appropriate to share that information with. So having some kind of strategy about how you're going to reach out to those folks and whether, all things considered, it's necessary given the potential risks. Those are some strategic considerations that you need to work through. To the extent that the witnesses are within the four walls of your organization, make sure that you have a strategy to ensure that whatever evidence they may have is preserved and maintained. To the extent that you're providing employees with electronic resources, cell phones, laptops, tablets, etc., they generally have no reasonable expectation of privacy for information contained within one of those devices. So you have the ability to retrieve those devices, conduct whatever kind of forensic examination of them you want to, and you can do that without having to get their permission to do so. Another thing that I'd recommend you put in place is something called a hold notice. And what that is a notice that's sent to anyone who may have helpful information or useful information regarding the allegation being investigated. And the hold notice asks them, or directs them rather, to preserve any electronic documents, any handwritten documents, anything at all, any electronic files that may have something to do with what you're investigating. The hold notice should be broadly phrased so that it captures anything that's potentially relevant. It's much better to have too much information than too little information. Relatedly, to the extent that you have data deletion policies, such as email boxes are automatically cleaned out every 30 or 45 or 60 days, you should examine whether you need to suspend those deletion policies to ensure that something that might otherwise be relevant isn't inadvertently deleted and you no longer have access to it. You also need to have a strategy and think about how to capture things that may not be contained in a computer or in a hard copy format. Getting text messages from employees, and if you have some kind of internal chat platform, take the steps necessary to capture those things. Many times with the text messages, it'll require that you contact the cell provider, and there may be a cost associated with that, but in most instances, that cost is worth bearing to make sure that you don't miss any relevant communications that might speak to the investigation. Also, to the extent that your employees are using personal email accounts in connection with their work activities, figure out a way to get at those things as well. Now, in the past, I've tried to get information from Google and Hotmail. For those of you who are around the same age as I do, you remember what Hotmail was. And it can be fairly difficult, particularly if the account holder doesn't want to assist you with that. But to the extent that your employees are perhaps sending work from their work platform to their personal email account so that they can work on it at home or on vacation or so forth, try to capture those to the extent that you can. In addition to taking efforts to secure that data and those pieces of information, you may need to limit a witness's ability to access data or files. For example, if there's a document that's at the crux of what you're investigating, then limit someone's ability to go in and modify that document, change the metadata, or to delete emails or other electronic files that you might want to look at. I would not rely solely on someone telling you, hey, I've looked everywhere, I provided you with all of the information that you've requested. I made that, I don't want to say it was a mistake, but I did that once with a case that I had. It was an age discrimination case, and the other side asked for a number of files. I asked my client's HR director to secure those files and provide them to me. They did that, but when I had to go in front of the judge to talk about the extent of my efforts to secure information, he asked me if I had physically gone to the client and looked for myself at their cabinet files to see if there was anything else there, and I had to confess that I had not. And so the judge directed me to do that. So that may be, and that's something that I would consider doing on a case-by-case basis, but I wanted to at least bring to the table the notion that you may have to physically go and look for files yourself rather than relying on what witnesses tell you they've done one way or the other. You should consult with your IT personnel about what you can do to preserve electronic files. They may have the ability to secure or retrieve emails or text messages or instant messages in a way that that you may not know about, but it's very important to get them involved on the front end so that you can bring the full, bring their resources to bear to make sure that you're doing everything you can to secure and preserve any electronic files that are relevant to the investigation. Cloning hard drives is something that is a very regular and usual thing to do in this day and age. It would be a hard sell to tell a court or a judge or an administrative agency that you weren't able to clone a hard drive because it was cost prohibitive. That's the expectation, at least in my experience, is that to the extent that electronic files are part of what you're going to be investigating, then not having cloned the hard drive, it's not the best position to be in. Getting a certification from someone, that is an email or some kind of standalone hard copy document that they provided all the documents that you've requested and that they can locate, can be a good thing to put in place. Again, it's going to be on a case-by-case basis, but to the extent, for example, you're dealing with some kind of government agency, having a certification that you've looked in everywhere that you could look to try to locate responsive documents and you provided all of those documents, I think can be a useful thing. As I'm sure most of you have read in the news, that certification has become kind of a sticky wicket for the former president's lawyers when one of the lawyers certified that they had provided all of the documents from Mar-a-Lago, and it turns out that that may not have been accurate. And there are going to be repercussions for that attorney, but it also weakens the former president's position in that litigation. I'm not speaking to the merits of the litigation, but just from a strategic standpoint, a certification that everything's been provided that turns out not to be accurate can be problematic. So it's useful to have that certification as long as it's accurate. When you're conducting the investigation, very frequently, there may be additional things that are revealed as you're going through the investigative process. If those additional issues are related to what you're investigating, then you can fold them into your current investigation. However, if it's not related to what you're investigating, then my recommendation is to do a separate investigation. Right now, I'm investigating a matter where someone brought forth a complaint that a work procedure wasn't followed, a safety procedure wasn't followed, and in investigating it, I've also been made aware of some potential inappropriate relationships with a vendor. That doesn't really have a lot to do with what I'm investigating. It's information that has come to light, but that's not going to be something that I'm going to encompass within my investigation of this safety concern. Again, if the new issue that comes to light relates to what you're investigating, then you can fold it into your analysis and your efforts to vet that complaint. But if it's not related, refer to the appropriate resource and have that resource handle the investigation. Changing the focus and the scope of the investigation midstream is not an ideal situation to find yourself in. Number one, it opens the investigator or the investigation itself to criticism. That whoever is leading the investigation or initiated the investigation doesn't really know what they're looking for, or maybe modifying the investigation to fit what is being disclosed or discovered through the investigative steps. Changing the focus of the investigation also may require you having to go back to repeat some of the steps. That is, interviewing the same witnesses for the second time, making an additional request for documents or other items that you may have asked for before, but if you've changed the scope, you have to go back and ask for additional things. And it just doesn't look as professional and as orderly if you have to go back and do things over again. that's one of the reasons that I want to make sure when I start the investigation, I keep my focus pretty broad and narrow it as I move forward to make sure that I'm looking into what's looking into the concern that was raised. Another pitfall of changing the scope or focus of the investigation, particularly if you have to go back and interview witnesses a second or third time, is that the witnesses may be inclined to tailor their response, and if they know what you're looking into, they may shape their testimony accordingly. Another key to doing an effective investigation is having clarity as to who is leading the investigation. That may be the same person that's doing the investigation, but it may not be me. It may be someone in that department. It's important to have some kind of framework in place to make sure that whoever's doing the investigation, a department or an individual, that they're not compromised by internal pressure from some stakeholder within the organization to come to a specific result or outcome. And it may be necessary to put some kind of mechanism in place to make sure that the investigator does not feel pressured from a different department or from an executive within the company to take a direction with the investigation, or to come to a particular predetermined outcome. Frequently when an investigation is done, when I do an investigation, if I've been engaged by someone as a senior executive, they may ask me, well, how's the investigation going? And I do not, as a general matter, disclose my findings until the very end of the investigation. What I say is, well, I'm getting access to the documents that I need, and I'm getting access to the witnesses that I need. And so I've got the resources that I need to do the investigation. I don't give any kind of heads up about, well, it looks like this investigation has some merit. There are exceptions to that. For example, if there's a safety concern, or if there's an active environment of harassment that the complaining person needs to be removed from, then I might address that in my communications. But in terms of the outcome, I don't state what that is with my communications, because I don't want to predetermine the outcome. I want to gather all of the information and only then develop some conclusions based on that information. When the investigation is concluded, and as you move through the investigation, it's important to think about how that investigation is going to be memorialized. Witnesses are going to be interviewed as part of any investigation. Think about whether or not you want to have those witnesses sign a statement from the interview that you do with them about what they say, or whether you want to just rely on your note-taking in summarizing the relevant parts of those witness statements as part of a report. And to the extent that you're creating a written report, is it going to be a summary report just with the findings, or is it going to be a detailed report? Whether it's detailed or the level of detail, again, it depends on the specific situation. I've done investigative reports where it was very detailed. I outlined who I spoke to, what information that witness provided to me, and so forth. And others where I just provided a summary of what my findings are. But think about what you want to do in terms of memorializing the investigation. I think a written report of some level is usually helpful, if nothing else, to show what it is that you did. But in some instances, that written report is going to be shared with a third party. And so that possibility may have an impact on the level of detail that you include in a report. In doing investigations, my recommendation is to have one person conduct the investigation from start to finish. That may extend the time frame that it takes to complete the investigation, but among the benefits of having one person do the investigation from start to finish is that investigator is in the best position to assess a witness credibility. If I talk to person A and then person B, and person C tells me, well, you shouldn't know that person A may tell you X, Y, and Z, but here's why you shouldn't believe them. I've sat down, I've been in contact with person A, so I can make that assessment myself. Having one person do the investigation from start to finish also allows a more sound decision to be made as to whether the issue, a new issue that arises during the course of the investigation, needs to be handled through a separate investigation, or whether it can be included in the first investigation. There are some situations where, for whatever reason, it may be necessary to have two people conducting witness interviews. The only time that I will do that and involve a second person in doing the interview is if I feel like the interview is going to be pretty involved and it's helpful to have someone to just transcribe or take notes of the interview, and I can focus on just asking the questions and getting the answers. Also, when doing witness interviews, I think about the order and sequence that I want to conduct the interviews. In a workplace conduct investigation, the way I will sequence it is to interview first the person who complained about the workplace conduct, interview any witnesses that they identify, and then the last interview I will do will be of the person who's alleged to have engaged in the unfavorable workplace conduct. The reason I want to talk to the alleged bad actor last is I want to have the ability to ask them about all of the different incidents that led to the complaint being filed. And talking to the complaining party, all of their witnesses, puts me in the position to, I don't want to say confront, but to present to the alleged bad actor all of the events that I want to include in my analysis. And after I talk to the alleged bad actor, they may have witnesses that they want me to interview. And so at that point, I'll talk to those other interviews. But that's how I will generally sequence the interviews in the workplace conduct environment. Now, with other kinds of investigations, you may want to sequence it differently. But as a general matter, the last interview that I will do is with the alleged bad actor, so that I have the benefit of I have the full universe of all the actions I want to get their feedback on. I also will give some thought to where I do the interview. These days, and with the last couple of years, a lot of things being transformed or done online and through Zoom, you can do the interviews wherever. But if I'm doing the interviews in person, I will most often go to the client's location, but I won't do the interview in the individual's office, because I don't want them to feel completely comfortable and distracted by watching emails and so forth. So I will, if I'm doing an on-site interview, I will ask for a conference room or something away from the witness's usual work location, so that they don't feel completely as comfortable and as distracted. When conducting witness interviews, one of the first things that I do is let the interviewee know that they won't suffer any kind of retaliation by participating in the investigation. Most companies, nearly every company that I've done an investigation for, has a policy that prohibits retaliation for bringing forth a complaint in good faith or for participating in an investigation. And there are, here in the US, it's against the law to retaliate against an individual for participating in an investigation or for bringing forth a good faith complaint. What I do when I interview witnesses is I tell them, in separate and apart from whatever the company's stance may be about retaliation, I, as an interviewer, as an investigator, want to assure them that they won't suffer any ill consequences from talking to me. And so I give them my personal contact information and direct them to contact me if they are asked to change their story, or if they feel like they've been treated differently simply because they spoke to me and participated in my investigation. There's a difference, however, between not being retaliated against and suffering no consequences for other kinds of workplace events. Sometimes interviewers, or interviewees rather, feel as though participating in an investigation and or bringing forth a complaint gives them some kind of immunity. And this is a pretty regular occurrence when someone comes forth with a complaint in the employment context, in my experience. They feel as though, okay, I've made a workplace complaint, so I can't be counseled for performance issues, I can't be counseled for attendance issues or anything along those lines. So when I do talk about non-retaliation, I don't provide any kind of guarantees that the person that I'm talking to won't be held to the same expectations, workplace expectations, as they would otherwise be. I think it's important to make that distinction between not being retaliated against and still being held to the same policies and procedures and expectations that they would normally be held to. When conducting witness interviews here in the United States, there's something, if it's in the corporate context, called an upjohn warning, and that is when an in-house lawyer does an investigation. There's a number of components to it, and I don't want to get drilled down too far on it, but the sense of the upjohn warning is the in-house lawyer tells the witness, I'm representing the company, I'm not your personal lawyer, and letting that individual know clearly kind of where your interest is and what your allegiance is useful, just to make sure that there's not any misperception about the stances of the two different people. When I do an investigation, I'm interested in gathering the facts, and I'm not there to advocate for the employee. In the harassment context or the discriminatory conduct context, again, even though I might be sympathetic to someone experiencing untoward things in the workplace, my job is not to be their advocate. It's just to get to the full extent of what happened, report that on to the company, and then let the company take whatever action they deem appropriate in response to what I found. Employees, there may be something in when I do employment handbooks and so forth, employees are obligated to cooperate with an investigation. And there are different parts of your policy framework that you can probably point to that speaks to that obligation. And if someone declines to participate or cooperate with an investigation, then you can take some steps to address that, up to and including termination. Now, obviously, that's kind of the nuclear option, and you may not need to use that, but you don't have to simply allow an employee to say, well, I don't want to participate in the investigation. You have they're not an obligation on their part to do so. And if they decline to participate, then that's something that you can document as part of the investigative report or your investigative findings. When I do witness interviews, I don't have a list of questions that I ask. What I use instead is just some bullet point topics that I want to cover. And I ask open-ended questions. Tell me what happened. The reason I don't use a list of questions is because when I ask a question, I want to make sure that I'm focused on whatever answer the witness is providing. Because very frequently there's going to be several follow-up questions generated by the answer that they provided me. So I don't use a list of questions. I do make a list of topics that I want to cover and just ask open-ended questions to elicit information and generate follow-up questions and lines of inquiry. Frequently when I do a witness interview, they may have some documents that are pertinent to the investigation. And what I do in those situations is I'll ask the individual what they can remember before we start talking about what may be memorialized in the documents. Frequently, I found that doing it that way, that is asking them what they remember independently and then going into the documents, provides some additional context beyond what is just set forth on the page. When doing an interview, my goal is to gather the facts. That is what happened. I'm not as focused, at least in the first part of the interview process, in hearing an explanation as to why something happened. What I want to get at is what happened. And then if someone wants to provide an explanation as to why it happened, I'll take note of that. But first and foremost, I want to get the facts surrounding the complaint or the conduct that I'm been asked to investigate. Don't be afraid, and you really need to probe to get a full response. If you ask a question and someone kind of partially answers the question but doesn't fully answer the question, you need to circle back and probe until you get as much information responsive to that question as you can. I also generally ask a complaining party in the employment context, what is it you would like to see happen? And when I do that, I'm not suggesting that their desired outcome is what's going to happen, but it is useful information to know what they see as the appropriate way to address the concern that they've raised. When I do interviews of witnesses and complaining parties, I ask them to tell me everything that's bothering them, or everything that has happened that is untoward, or that they believe is discriminatory or was harassing. I don't think there's any benefit to giving short shrift to someone or telling them, okay, I've heard enough and so forth. What I want to do is to make sure I have the full universe of concerns or allegations, and then I can address each one of them. When I do this, when I take depositions in a harassment case, I ask the witness to list everything that they believe constitutes harassment. And after they give me a list of all those different things, then I will ask them specifics about each different allegation. And I'll ask them, is there anything else that you can think of? They say no. Are there any documents you can review that might allow you to remember anything else? What I want to do is to make sure that when I conclude that interview, that I've got the full universe of complaints that they want to raise, to prevent them from a week or a month or a year later saying, oh, there are some other things too that the company didn't look into. If I can get all of the allegations out during my interview, I can put a box around them and then address them, or or give them to the client so that they can address them as they see fit. During the witness interviews, after getting all the information that I can from that individual, I'll ask them if there's anyone else that they think I need to talk to that might have information about the complaint or the concern that I'm addressing or investigating. I'll ask if they've discussed their concerns with anyone else that might be a witness. And if they haven't, I'll instruct them not to contact any other witness or discuss my questions with any other witness. And the reason I do that, I tell interviewees, is I want to preserve the integrity of the investigation. I want to get full information, and to do that, I need to be able to tell the witnesses that I'm not going to share the details of what they told me unless necessary. And likewise, I need to make that same representation or get that same agreement with you. And so I need you not to contact witnesses to talk about this investigation or our interview. And to make sure that I drive home the thinking behind that, I ask this question: if you do discuss this with someone else, wouldn't it be reasonable for me to conclude that you're trying to impede my investigation? That kind of puts it front and center why I don't want the person to talk with other witnesses, and what I'm going to assume their intent was if they do try to contact witnesses that I had yet to talk to. If the witness says that there are documents that they have, then of course request those documents, but specify that they produce them to you within a certain time, rather than, if you can send me those documents. If I talk to a witness, say, well, can you get those documents to me by the end of business tomorrow? And nail them down as to when they're going to get the documents to you, so that it's not something that's out left hanging. I also, when I do interviews, end the interview with a catch-all question. Is there anything you think I should know that I haven't asked you about? And I let the witness know that it's not some kind of trick question, but I'm coming into the situation without having the same level of knowledge that they do. So I want to give them the opportunity to add to whatever information I have, if there's something that I don't know, but I don't know. There will be times when you need to circle back with an interviewee to talk with them again. An investigation that I'm doing right now, I had to circle back with the witness because there was a document involved. I spoke to witness A, who said, this is what the person's signature in this document means. And so I had to go back to the witness and ask them, person A said your signature on this document means this. Is that accurate? Don't be afraid to make credibility assessments. And that's part of doing the investigation, is you have to make assessments as to whether or not you find someone's testimony credible. And it's not necessarily something that is a matter of opinion, but if 3 witnesses say something happened a certain way and one witness says it happens in a completely different way, then as an investigator, I feel like I need to make some assessment as to which version of those 2 events is more credible. And if there is a fact that's in dispute, then you need to ask that interviewee how there's such a difference in the 2 versions of events. And this is one way to do it without calling them a liar or saying that they're not telling the truth. Is everyone I've spoken to remembers these things happening differently. How would you explain that discrepancy? And then give them the opportunity to explain why they think everyone else besides them saw the situation or experienced the situation in a different way. Many times I'll ask, when there's a situation of a discrepancy, I'll ask them directly if they believe the other witness is not telling the truth and why that other person would not be truthful. There's no benefit to not asking these questions if an interviewee suggests that someone else might be untruthful or may have some kind of agenda. Again, the purpose of the investigation is to get as much information as you can so that you can make an assessment and make informed decisions. When doing witness interviews, these are some things you can do to combat a witness either being coached or having a script in their head about how they're going to address your questions. Rather than ask the witness to tell me things in chronological order, I'll have them do it in a reverse chronological order. Sometimes if they're telling me things and I feel like they're either trying to follow a script of some sort, I'll toss in a random question. For example, if they're telling me about all the different things that were done that they believe were harassment, I may just pop in, oh, by the way, where did you go to college, or where did you go to university? What did you study? Something to kind of disrupt their train of thought and their flow of thought so that they can't really stick to that script that they have in their head, instead of providing you with the full and most accurate information. It can also be useful to sometimes ask the interviewee to make a drawing of the event. If it's, again, the harassment context, where were you sitting? Where was the other person sitting when they engaged in this conduct? What did the room look like? There are some witnesses that can be difficult to deal with. Sometimes the interviewee attempts to control the interview, and it's important to let them know and to communicate that you control the interview process. The flow of information is going one way. That is, the interviewee is providing it to the interviewer and not vice versa. Another problematic witness can be one who does what I call the information overload. I did an investigation that involved someone's IT department, and one of the witnesses just tried to bombard me with all these technical terms and acronyms that I had no idea what they meant, and I think they knew that, but they wanted to use that as a strategy to prevent me from getting at the information. And what I did is I let them say their piece. I said, okay, now that's different than what I asked you, so I need you to focus on this. But that's just a strategy that some witnesses may use that I wanted to make you aware of. To the extent that you are doing an interview for a witness and they have some kind of representative available, if it's a union context or if it's someone's attorney, if you allow that, what I do is generally I don't allow a representative to be in the room with me when I do my interview. But if they are in the room, I'll let them know that they're there to observe, not to participate. And if they're going to interrupt, then they're going to have to leave the process. And if they refuse to do so, then I will note that as part of my investigation. Sometimes interviewees say that they want a copy of the notes from the interview, and I generally do not do that. You know, I'm gathering information, I'm conducting the interview. I tell the interviewee, to the extent that it's appropriate for you to learn anything about my investigative findings, then the company will provide you with that information. If the interviewee says that they need to have an attorney present during the interview, I generally won't allow that, because that's just not something that's required under the law here in the States. And it usually just causes disruption in trying to get that information. There's no obligation to consult with someone's attorney or to allow the attorney to attend the interview. Likewise, there's no obligation to allow someone to record the interview. And I generally confirm that when I do an interview and it's not in person, that they're not taping the interview. Sometimes interviewees demand that what they tell me remain confidential, and I tell them that I will to the full extent possible, but there's some things that may come through from the interview that I have an obligation to report. For example, if there's some kind of safety concern that comes forth. Likewise, if they ask for a copy of the investigative report, I decline to do that and say, to the extent that information from my investigation is going to be shared with you, it will be through the company. I mentioned earlier about not making an interim report. This is a situation where I might do so if there's circumstances that require some kind of temporary assignment, removing someone from a bullying situation, or if there are billing improprieties that need to be ceased, then I might make some kind of interim report. When you create the report with the findings, assume that someone else outside your organization is going to see it. Communications with in-house counsel are deemed privileged on certain circumstances when it's to provide legal advice, but the facts that an in-house counsel may learn, the facts are not privileged, but the legal advice is. The report should cover who, what, when, where, and how, and it should be a statement of the facts that you learned rather than expressions of opinion about whether or not this is bad conduct or anything along those lines. When constructing a written report, that report should include what was investigated, who was interviewed, what documents were gathered and reviewed as part of the process. It should also identify what witnesses and documents were not available to review or be interviewed. And it should set forth your factual findings. Sometimes I'm asked to provide recommendations to a client, not usually, but sometimes. But generally what I do is I make my factual findings and set those forth. It's important to phrase things, be thoughtful about how you phrase investigative findings. So for example, inconsistent with policy versus violated policy. I knew a situation, a sexual harassment investigation, and the investigator said, this person violated our policy against sexual harassment. And then when the individual filed a lawsuit, that employer couldn't say, well, it wasn't sexual harassment because their own investigator had reached that conclusion. if they had instead written that this individual engaged in conduct that was inconsistent with our harassment policy, then you at least have the ability to make that argument. We're getting near the end here and I'm almost done, so I'm going to continue to plow through. The person who has brought forth a complaint, when to share what steps you're taking, I advise against avoiding letting them feel like they can dictate what the outcome is going to be. I liken it to making a police report. If you see a crime, you may call the police and say, hey, someone's broken into my house. You don't have any control over what the police are going to do to investigate it or what the court is going to do to the person who broke into your house. So that's, I think, a useful way to think about how to communicate with the complainant. The person who is accused may want to be exonerated, and they may want some kind of public exoneration. And what I advise clients to do is to say, we've done the investigation, we're taking remedial steps to address it. Unless there's something that this complaint was made in bad faith and violated our policies, that's what we're going to do. Potential retaliation, the complainant should not be treated any differently than they were before they raised the complaint. That is, any performance issues they had before raising the complaint can continue to be managed. They should not, however, be deemed a troublemaker or something along those lines simply because they brought forth a complaint. Copycat claims, sometimes when you do an investigation and you do witness interviews, that may generate additional complaints along the same line as what you're investigating. And if you've been able to address those, if it's the same actor, for example, you may have been able to address those within the context of your investigation. This is an example that I have provided. We don't have time to go through it today, but it's in the material. So I just provided just to see how some of these things can get kind of sticky. Susan lodges an internal complaint that she was touched without consent. She says she's going to speak to an attorney and go to the police, and for that reason she declines to interview. Jim denies it, has an attorney, has a polygraph, and wants that to be part of the investigative package. And then Jim says that he and his attorney are going to go on television to clear his good name. To the extent that, and using this example, what you can do is to say to both Jim and the complaining party, we're going to do our investigation. We're going to follow our procedures. To the extent we need to take remedial action, we're going to do that. And if you want to go beyond that, that's out of our control. But we're going to do what we need to do. We're not going to let the potential criminal matter forestall what we do as a company to look into this complaint and take whatever action we need to take. So that's a very, very quick run through an example, but I want to at least cover it. So we're right up on 2 o'clock. I tried to get through this without rushing it. To the extent that you have questions, please feel free to shoot them to Lucy or let her know, and we will be able to address those. And short of that, I want to thank you for the time today and for your attention. Lucy, I'll turn it back over to you.